Hi, students. I'm back. This is Unit 6, which is interrogations and confessions. Unit 6, of course, corresponds to Chapter 6 of your textbook. It's, in a way, a milestone because at this point you are halfway through the book and halfway through the class. Unit 6 is covered in week 10. So, what about interrogations and confessions? Before I get into that, I want to give you a little bit of information, really about the criminal law that applies here. So, first of all, when we talk about criminal law, we talk about two aspects of it. One is the substantive criminal law, which is the body of law that will, which will define the crime. For example, what is a robbery? What is a burglary? Uh, what is murder, manslaughter, so forth. So it defines those crimes, but it also sets forth the punishment for the crimes. Where do you find that law? Well, generally you find that in a code. California is a codified state. Most crimes are in the penal code, but you do find some in the vehicle code. You'll find drug crimes in the health and safety code. So it just depends, but most of them are in the penal code. The other aspect of criminal law is what I refer to as procedural criminal law. That law is the law that sets forth the procedure that has to be followed in order to process a criminal case. So, for example, it defines when a police officer can make an arrest. Uh, After that, it will define the arraignment, for example, or the preliminary hearing, the trial, sentencing. All those are procedural aspects of a criminal case, and generally they're set forth in the penal code. That's the first thing I wanted to mention to you. The second thing I wanted to mention to you is what is the difference between a police interview and a police interrogation. Regarding an interview, police officers, no matter if they're working patrol, detective, or some other assignment, um, they are in the business of gathering information. It's from that information that they solve crimes and make sure that justice is served, either by bringing the person that's responsible, uh, to trial, or exonerating, or determining that the person did not commit the crime. So it's a search for truth in a way, and they do that by interviewing people and gathering information. So that's what an interview is. It's a non-threatening way of gathering information. Interrogation, on the other hand, it's focused. It's focused on the person that they believe committed a crime, and the goal of that interrogation is to um, obtain a confession or an admission. Um, so when we talk about a crime, there's two aspects to a crime itself. There's what we call the actus reus and the mens rea. The mens rea is the mental state of the perpetrator. So there might be a requirement of general criminal intent or specific intent or knowledge. So there's this mental state component to every crime. So, for example, a burglary is the entry into a building with the specific intent to steal or commit a felony. So that is an example of specific intent. The perpetrator had to have that mental state. Another example would be receiving stolen property. The person receives a stolen property with the knowledge that the item was stolen. So the mental state is knowledge that the item is stolen. So every crime has a mental state. Also, every crime has an act. So there has to be the act and the mental state. In my example of a burglary, the act is going into the building to commit the theft. So that's the act, going into the building. The mental state is with the specific intent to steal. So that's an example of the act and the mental state, and they work together. They have to be there together in order for a person to commit a crime. So, for example, if the person entered a building, they didn't have the intent to steal, you don't have a crime. Or if they were thinking about, well, I want to enter a building to take something, but they never do it, you don't have the act, you don't have a crime. So they have to work together, and then in that manner, a person will commit a crime. So when we talk about a confession is a statement of all the facts necessary for a conviction. So when an officer is interrogating a person, the goal is to get a confession, which is an admission of not only the mental state, but also an admission or statement regarding the act. So it includes both the act and the mental state for that particular crime. That's why it's important for officers to understand the definition of a crime, what is the act and what is the mental state. So when they interrogate, they know what the goal of that interrogation is. The other type of statement that a perpetrator can make is what I call an admission. It's less than a confession. It is a statement about the crime that can be used against that person, but it falls way short of a confession. As an example, the person say, "Well, I was there, but I didn't do anything." See, so he puts himself at the scene, but he doesn't confess to the crime. But that statement can be used against that person. Or a false statement. For example, I wasn't there, and they have fingerprints or they have cell phone records that put that person there. That kind of statement can be used against the person. It would be an admission. So you have to have that background to understand interrogation and confessions in this chapter. So what rights come into play? You know, the last three chapters primarily were on the Fourth Amendment. We talked about contacts, we talked about search and seizure, we talked about surveillance. That was all in the Fourth Amendment. When we talk about confessions and interrogation, we're talking about several different rights that come into play. We have the Fifth and 14th Amendment due process clause, which requires that a person's statement has to be free and voluntarily made. And I'll get into that in a moment. Also, you have the Fourth Amendment exclusionary rule. You have the Fifth Amendment privilege against self incrimination. And then lastly, you have the Sixth Amendment right to counsel. So you have those rights that come into play when we talk about confession and interrogation. When we talk about the free and voluntary rule, that's under the Fifth and 14th Amendments, due process clause. Confessions have to be voluntary in order to be admissible. The purpose of the rule is to protect against a conviction on unreliable evidence, preserve a defendant's freedom of choice, and to deter police misconduct. So a confession, here's the rule, a confession is involuntary if it results from coercive pressure exerted by the government that overcomes the defendant's free will and induces a statement that the defendant would not otherwise make. The source of this pressure has to be from the government. So there's different types of pressure I want to talk to you about. There's what I refer to as extreme pressure. And extreme pressure will result automatically in a confession being deemed to be involuntary, and the confession or admission would be suppressed. What are examples of extreme pressure? Uh, the extreme types of pressure that I'm referring to is physical force, threats, and false promises. If a police officer engages in any kind of physical force to extract a confession or admission, game over. That confession is involuntary. So an officer cannot hit, push, um, use any kind of force on that person to get a confession or an admission. If the officer does, confession is going to be suppressed. What about making threats of force? Can an officer do that? No, it would be involuntary. So I can't threaten to kick a person's butt, so to speak. That would be involuntary. Um, can you threaten other people? Can you threaten to arrest them? Can you threaten to call CPS and have the children removed, or threaten that you're going to disclose personal information? Maybe the person is, bisexual or gay, and maybe they're not out, and you have that information, and you tell the person, if you don't tell me what happened, then I'm going to disclose it. That would be involuntary, right? You can't threaten, to arrest or take any action toward a family member. If you do that, it's a threat. It's going to be involuntary. So physical force and those types of threats render a confession or an admission involuntary. What about false promises? Can an officer make a promise that he cannot keep in order to get or obtain a confession or admission? The answer to that is no. So the officer can't say, well, if you tell me what happened, I will guarantee you probation. The officer does not have the authority to say that. An officer cannot, promise a person a particular sentence. Only the prosecutor can make that kind of agreement. A police officer cannot do that. So if the officer is making any sort of false promises, that's going to render that confession or admission involuntary. There are less forms or less severe forms of pressure that is exerted. There's psychological types of pressure, and there's also use of trickery. Regarding psychological pressure, that includes techniques like asking a person if they've asked God for forgiveness. Do they need forgiveness or mercy, or do they need some sort of justice? There's all sort of techniques like that. You can tell the person that, by let's make sense of this craziness here. You can help make sense. You can give closure to the family. You can appeal to the family. You can tell them that you're going to advise the district attorney that they have cooperated, and hopefully they'll get a better deal by cooperating. You can also give them an excuse for what they've done. So instead of making it sound like it was first degree premeditated, a gruesome murder, you can give them excuse saying, well, maybe that person deserved it. Maybe it was self-defense. You were acting out of fear. You give them an excuse to get that admission or confession. So there's different forms of psychological pressure that you can use to obtain the confession or admission. There are also different forms of trickery. Now, officers are authorized to lie. I don't know if you knew that, but they can. They can lie about all kinds of things. They can lie that, for example, that they were identified by a witness, that they were on caught on camera, a video, that their fingerprints were found at the scene, or DNA. They are authorized to lie. They're authorized to lie to seek the truth. And normally, these types of lies and trickery, and even the psychological pressure I mentioned, does not result in an innocent person making a false confession. But you got to be careful about false confessions. So when you have a confession, you have to make sure that the confession or the admission matches the physical evidence. If it doesn't match, the officer has a problem there. You got to be very careful about that to avoid that. Um, so generally, when you have these less extreme types of pressure, the court's going to look at the person's susceptibility to making an admission or confession, and the court's also going to look at the conditions of the interrogation. When we talk about susceptibility, everybody's a little different when it comes to pressure, I think. Some people can handle a lot of pressure, and some people, as soon as the officer looks at them, they start crying. It's kind of like if you have children, you know this. There's always one kid that in the family that you look at them and you ask them, what did you do? And they burst out crying and they'll tell you right away. And there's the other kid that's totally defiant and they'll take a whooping before they say anything, right? So it's kind of like that. Everybody is different as far as susceptibility to pressure. So the court's going to look at that. They're going to look at the person's education. So generally speaking, the higher the education of the person, the more likely they can resist pressure. Also, general intelligence. The more intelligent that you are, it's most likely that you can resist pressure. Physical condition. If you're in good physical condition versus poor, you have some sort of physical issue, physical disability, maybe, or just a health issue that can make you less susceptible to pressure. You might, just give in a little bit more easily than someone who is very healthy and robust. What about a mental condition? A person that is sound mentally may be able to resist the pressure more than somebody that has a psychological issue going on. Maybe they have schizophrenia, bipolar, some other mental health issue that might make that person a little bit more um, less susceptible to the handling this pressure. Um, Experience with law enforcement and their criminal record. Generally speaking, it's believed that people that have experience with the criminal justice system, they've been arrested and been contacted by the police, are more are able to resist pressure from law enforcement. Um, and But not always the case. And then also there's other factors that can be considered as well. It's just on a case by case basis, but you have to look at their susceptibility to the pressure. I do want to mention, why do you think people even talk to the police? Well, there's a lot of reasons for it, actually. I think sometimes the more serious the crime, maybe they feel this pent up guilt and they want to get it off their chest, so to speak. That could be a reason for it. In a lot of cases, though, they want to speak because they want to find out, they don't want to confess or make an admission, but they want to find out what the police know. And the police are, in a way, smart about doing this. They're not going to play their hand until what? The person waives their rights, which we'll get into, and then they agree. Uh, they waive their rights and agree to speak, and then there's this conversation they have. But a lot of times, the people will waive their rights and they'll agree to speak because not because they want to make the confession or admission, it's because they want to find out how strong the case is of the government, how strong is the case against them. And for that reason, they are willing to speak. The other thing about less forms of pressure in this area is the conditions of the interrogation. Interrogations can take place at a lot of different locations. It could take place at the person's home. It could at work. It could take place, outside in a car. It could sometimes you try to interrogate over the phone in a way. The best place is where? The best place is at the police department. Do you think officers are controlled on how to interrogate and obtain confessions and admissions? I can tell you absolutely yes, they are. Even in my own experience, when I was in college and I was a criminal justice major, I took a full semester class on interrogation and confession and admissions. I took a whole semester class, and and then after you become a police officer, you go to the academy, you talk about it on your field training program. You have more training on it. If you are transferred to a specialty assignment, say detective, then you're going to receive more. So officers are very highly trained. Anybody that thinks that they are not trained are going to make a mistake. They are very foolish if they think that officers are trained. So the conditions of confinement that may, or conditions of the interrogation that may render this confession involuntary can include things like the length of it. So the longer you go, the more risk you take as an officer that it will be rendered involuntary. Is there a line there? I don't think there's a line, but you have to be aware that if the person is hungry, what do you do about food? What do you do about sleep? So you have to be careful about that the longer you go. The intensity. If you're more intense and intensity, I mean, are you confronting them with evidence? Are you confronting them, with not being truthful, not telling them, hey, you're lying. I need to know the truth. Are you confrontational with them? Again, the location, sleep, food, even medical deprivation. You got to be careful. If they have a medical condition, if they're hungry, if they need food, you should make sure that those needs are being met, because if you don't meet those basic needs, then the court's going to look at that and may conclude that, hey, the conditions of the interrogation were such that it rendered this admission or confession involuntary, and then it'll be suppressed. They'll also look at the presence of officers and their conduct. So, for example, if it's a one-on-one or two-on-one interrogation, generally that's not going to be a problem. But if you have 5 officers surrounding the person, that might be a problem, right? And what are the officers doing as they're interrogating? Are they slapping their handcuffs around? What are they doing exactly? Are they being respectful? They're going to look at their conduct. So that ends that first category. It has to be voluntary. What about the Fourth Amendment rule? The Fourth Amendment comes into play. We'll never shake the Fourth Amendment. It's a very important amendment, and you know the reasons for it. But just let me say this, and I'm not going to say much about it, but if you have an illegal arrest or an illegal search, which is a violation of the Fourth Amendment, and that's then directly connected to a confession. So for example, you make an illegal arrest because you don't have probable cause, right? And then that immediately after that, you obtain a confession. That confession will be inadmissible. That's why it's so important for officers to understand those contacts that we mentioned, what's required for an arrest. They do it correctly, because if they don't and they obtain a confession or admission, then guess what? You're going to lose the confession. Not only that, guess what? What happens if during the confession they did confess and then they told the officer where additional evidence is located? And the officers go out there based on that confession and locate additional evidence. It's not only the confession that's going to be suppressed, but it's also the fruit of the poisonous tree. It's the fruit of that confession, which is the fruit is the additional evidence. That evidence will be suppressed. So it's very, very important that officers understand that. What about, I want to shift gears and talk about the next constitutional right that comes into play, and that's the Fifth Amendment, privilege against self-incrimination. So we all have this privilege against self-incrimination. Is it a good thing to incriminate yourself? Well, it depends on which side of the fence you're on, so to speak. If you're on law enforcement's side of this fence, you want that person to incriminate yourself. That's the goal of the interrogation, to get the confession or admission. If you're on the other side of the fence, either you're the person that's being interrogated, or have some sort of relationship with that person. You don't want to incriminate yourself, but everyone has that privilege. So even if you're not in law enforcement, again, I've said this over and over, you need to understand your rights so you can protect your rights, right? So let's talk about Miranda. Miranda is operative. When is Miranda operative? That's an interesting question. So when I was just starting off as a judge, I would do these arraignments in court, and the person being arraigned would say, "Your Honor, the officer did not advise me of Miranda." Well, sir, the officer did not have to advise you of Miranda, and they looked perplexed. So Miranda is operative when you have custodial, so you have the person in custody, and interrogation. So it's custodial interrogation about this uncharged crime. So it actually has three components: custodial, interrogation about the uncharged crime. And if you have those three elements, then you're going to have to advise that person of their rights pursuant to Miranda. And we all know those rights. Miranda was a case. Went up to the U.S. Supreme Court. His name was actually Ernesto Miranda. It was a case out of Arizona, and he committed a sexual assault on this victim. Actually, he picked up the victims, assaulted her, and took her home. Nice guy, right? Anyway, they identified him, brought him into the interrogation room, interrogated him, and confessed. Now, of course, they didn't advise him of Miranda because Miranda didn't exist. This is the case that created those rights. And this was a 60s case. Anyway, he was convicted. He appealed. It goes up to the U.S. Supreme Court, and they reversed. The interesting thing about Miranda is that at his retrial, he's convicted. He was sentenced to prison. He was released, and then guess what? Well, you have to watch the film. Sorry. But anyway, so Miranda gets triggered when there's custodial interrogation about the uncharged crime. So the person has to be advised of his rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to a lawyer. If you cannot afford a lawyer, one will be appointed to represent you free of charge. And you can exercise these rights at any time. So you have the right to remain silent. Anything you say can be used against you. You have the right to a lawyer. If you can't afford one, one will be appointed, and these rights can be exercised at any time. Those are basically your Miranda rights. You've all heard them. So the officers have to advise a person of their rights. They have to obtain a waiver of their rights. Now, the waiver can be either express, which means, yes, I'm going to give up my rights. I give up my rights, officer, and I'm going to talk to you. I'm going to tell you what happened. That's an express waiver. There's also what we call an implied waiver. So once the person is advised of the rights, the officer doesn't ask them, do you understand them? Do you want to talk to me? The officer just tells the person what the rights are, and then just asks questions. If the person answers those questions, then that's an implied waiver. So you have an implied waiver, and then the officers have to stop questioning if the person invokes their rights at any time. However, this has to be very clear. It can't be ambiguous. It has to be very clear that the person does not want to talk to the officer or wants a lawyer. It better be clear. So if the person is not being clear, there's two thoughts. One is that the officer can just ignore it, or they say the better approach is to clarify. So you just stop and you ask the person, are you telling me that you want to remain silent? Yes, that's what I'm telling you. Then the officer has to stop. If he clarifies and the person says, no, 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 I want to talk to you, then he's clarified it. Or if he goes, I'm thinking about a lawyer, what do you think? And the officer says, well, are you asking me that or telling me that you want a lawyer? And the person says yes, then it should stop. If the guy says, no, I'm just asking what you think, no, I want to talk to you, then you move on. The reason for clarifying it, the reason that it might be better is you clarify it, it's clear, and that the statement is going to be admissible. So I want to talk to two aspects of Miranda. One is custody. What does custody mean? It's custodial interrogation, uncharged crime. But what does custody mean? It means actual custody. You've taken this person into actual custody, or it's the coercive atmosphere of custodial arrest. Actual custody is pretty easy. You've taken them into custody, you've arrested them. But officers have to be aware of the second one, because if they're not, you could get in trouble. If you violate Miranda, the statement could be suppressed. So coercive atmosphere, the court's going to look at the totality of the circumstances surrounding this contact, and they could determine based on these objective factors that the person was actually in custody. So what factors will they look at? Well, they'll look at the length of the questioning. Was a person isolated? The number of officers? The weapon? Were weapons displayed? Was a person touched? Was the officer hostile or aggressive or confrontational with the person. The language, the tone of voice, was it accusatory, restraints, confrontation? I mentioned that. So they're going to look at those factors. And if the court concludes, hey, wait a minute, the officer might have said that, this person was free to go, but when we look at these factors, it amounts to a coercive atmosphere of custody, then they will treat that person as in custody. So officers have to be very careful. They have to be thinking. This is a thinking person's game, so to speak. The officers have to be thinking about what they're doing and what these factors are so they can comply with Miranda. Also, what about interrogation? What does that mean? The express, questioning, or functional equivalent. So what is express? Well, it means you ask a person a question and they answer. That's all it is, express question. I'm going to ask them a question, they're going to respond. What is functional equivalent? It means that it's words or what? Words or actions by the police that they know reasonably likely will result in an incriminating response. There's a couple cases. There's Rhode Island versus Ennis, and there was two officers that had this guy in custody in the back of the car. He's clearly in custody, and the two officers were talking to each other, and one says to the other, "Well, I hope a kid doesn't find a gun because a kid could be shot." So, words like that. And the suspect in the back of the car told the officer, "Okay, I'll tell you where the gun's at." Well, he's charged, and they make a motion to suppress that statement because he was in custody. So you have that. It's an uncharged crime. Was this interrogation? That's the question. Was it an express questioning? Well, first of all, no, it wasn't expressed because why? The officers never asked him a question, but was it the functional equivalent of questioning? The court said no. It was probably a close case, but the officers were merely talking to themselves and having a discussion, about this missing gun. Compare that to the case of Brewer versus Williams. Brewer versus Williams is also known as the Christian burial speech. They have a missing victim and presumed to be dead at this point. They have the person in custody, and the officer um, gives a Christian burial speech. He tells the person, "Hey, we want to recover this girl, the victim, so the parents of this girl can give this girl just a proper Christian burial." And that's all he said. And then the guy thought about it and said, "Okay, I'll tell you where she's at." So was there express questioning? No, it was a speech, not questioning, but was it the functional equivalent of it? In other words, was it a statement that was likely to result in an incriminating response? Yes, it was. So in this case, you have custody, right? He's in custody, uncharged crime, and the question is interrogation. The court said, well, this is the functional equivalent of interrogation. So he should have been Mirandized. He wasn't. The statement gets suppressed. See how that works? Let me mention there are exceptions to Miranda. Generally speaking, those are for public safety. So let's say you arrest a person. He's a terrorist, and you believe there are outstanding bombs. He's the Boston Marathon bomber. They didn't know if there were additional bombs. They arrest him. Can they now he's in custody? It's an uncharged crime, and they want to interrogate him. Can they proceed asking him about questions because they're concerned about public safety, that there's more bombs? Absolutely. What about you arrest a guy, you believe from the evidence that he had a weapon, a firearm, but he doesn't have them at the time of the arrest? Can you interrogate him without Miranda to find that gun? Yes. What about if you arrest somebody, they're acting under the influence, and you need to find out what they've taken in order to get medical treatment for them? Could you do that? Yes, it's for public safety. So there are exceptions, but you better be careful. Better be able to articulate that. I don't think it's too hard. I mean, but you have to be thinking about that. Can you resume questioning after a person invokes? Yes, you can, but usually the person has to initiate the contact. So when I was a detective at the Concord Police Department, if I advised someone on Miranda and they invoked, they didn't want to talk to me, I'd say, okay, I cannot talk to you. I can't give you any information. I can't listen to you. but here's my card, and if you want to discuss this case, please reach out to me. Here's my number, call me, and I'll come and talk to you. So that's how I used it. And on occasion I'd have a person recontact me and want to tell me their side of the story. Not usually, but once in a while, that would happen. So that covers Miranda. The last one I want to talk to you about is a right to counsel. So once the person has been charged, now remember Miranda's for an uncharged crime. Once they're charged, it's not going to be the Fifth Amendment, it's going to be the Sixth Amendment. The Sixth Amendment will be triggered. So once the person has been charged, the person's going to be there, and they will be there during any interrogation, and important rights could be lost. The Sixth Amendment right to counsel is triggered. So before you can proceed, you're going to have to get that person to waive his right to have a lawyer. How do you do that if you're a police officer? The same way that you get them to waive Miranda. You advise them of the right, they understand their right, they give up their right. So if a person has been charged, you want to interrogate them. You can go to them even if they have a lawyer, even if they have hired a lawyer or appointed a lawyer at that point. You can go to them and ask to speak to them, but they're going to have to give up their rights, right to counsel at that point in order for any statement, confession, or admission to be admissible. Those are the ones that I wanted to talk to you about. Now, I do want to tell you this. Who has the burden to show that the confession or admission was obtained in a legal manner? It's going to be the government. How's this issue even going to be raised in court? So you have this confession or admission. Generally, what happens is the defendant is charged. The defendant has a lawyer. The lawyer is going to read the reports, and we're going to talk about that in the right to counsel chapter. But the defense attorney will read the reports, see that there was a confession or admission, and then make a motion to suppress the confession. So there's a motion to suppress. It's filed in the court. This is handled before trial. The issue has to be decided by the judge, not a jury. There's going to be briefing. There's going to be a hearing, and guess who's going to have to come testify? It's going to be you if you're the officer. So you're going to have to testify, and they're going to ask you questions about, was it voluntarily given? Did you comply with that? Was there a Fourth Amendment violation? That might be raised. Was there a Miranda issue that needs to be addressed, or a right to counsel to be issue has to be addressed? So the officer is going to have to testify about that. So the officer has to know these things to comply. Otherwise, the statement will be suppressed. So he has to know it. He has to be able to write all this in his report, and then he has to be able to testify at this hearing about that, so the judge can make the appropriate decision, either to deny the motion to suppress or grant it and suppress it. Now, if the confession's suppressed, that doesn't mean the case is over. It just means the confession is suppressed. The case can go forward. If the confession or admission is the only evidence or a big part of the evidence, then maybe the case would have to be dismissed, but not necessarily so. The prosecutor will have to evaluate the case and make a determination whether or not they can go forward. So anyway, that's the lecture on this unit, and I will let you go. I hope class is going well, and I will see you soon. Make sure you watch the video. It's a very good video. It's Films on Demand. There's a link there. You'll be watching that. There's a discussion question to participate in. Make sure you do that. That's worth some points for you. And I think that will really illustrate what I've talked to you about in this video. It'll illustrate what I've talked to you, and you'll see it for yourself in the video on interrogation that's part of this unit. So anyway, take care, and I'll talk to you soon. Thank you. Bye-bye.